Hi, and welcome to Is That Even Constitutional? This is a podcast where we use the lens of the Constitution to dissect current events. My name is Sadhana Devaraja, and I'm not a constitutional scholar, but lucky for me, my good friend Ken Thomas is. Hi, Ken. How are you?
I'm great, Sadhana. How are you?
I am doing well. So in our second season here, we are calling this the Project 2026 series, and we're setting forth 10 winnable proposals that would help us reclaim the Constitution through legislation. This is the seventh proposal of that arc. So far, we've covered ending the filibuster, ending gerrymandering, making Election Day a national holiday, setting term limits for the Supreme Court, ending the Electoral College, making D.C. a state. And today, we will be talking about the right to family autonomy, the right to plan your family, and really reproductive decision-making. So, Ken, to get us started off, can you run us through some stats on why access to contraception and abortion is so important?
Well, about 47 million women are currently on contraceptives, and there is a huge social benefit to this. This is something that we really saw when the pill, the contraceptive, the oral contraceptives that is used to prevent unplanned pregnancy was first introduced. This had a huge impact on society and probably even started the women's movement and the ability of women to enter the workplace. So after contraceptives were introduced, we have seen by women enrollment in college goes up 20%. We have seen an increase in the income of women, $200 per year statistically have been associated with contraceptive. Your women are much more likely to participate in the labor force because they can plan their career without being concerned about becoming pregnant. Women with access to contraceptives work more hours annually. Their children tend to have higher levels of education, and there is also a significant reduction in risky pregnancies. After the pill was introduced, there was a dramatic decline in infant and maternal deaths. And so these are the various benefits. The good news about contraception is that because of it, unplanned pregnancies are now at a record low. There has been an overall increase in contraceptive use, which is associated with these record lows. There are probably 2 million unplanned pregnancies that have been prevented by the use of contraceptives every year. And it turns out this is actually an economic boon to the federal and state governments because every $1 spent on contraceptives saves almost $6 of public spending. Still, there's some still concerning statistics. For instance, 45% of all pregnancies are still unintended today. And the reduction of these unintended pregnancies could save federal and state government expenditures, which would total about $21 billion per year. So obviously, contraceptives are so central to not only individual planning, but is also very central to our society and our social network and to our governance. So contraceptives is one of those issues that everybody has opinions on, but some people don't realize just what a significant thing contraceptive is in this day and age.
Thanks for running through that, Ken. And so, we're a show about the Constitution. And so can you talk to us about whether, contraceptives or reproductive planning, abortion, whether this is protected by the Constitution?
So this is a great question. The Constitution does not explicitly address contraception or abortion. However, the Supreme Court has found that, like many other what are called fundamental rights, that the government should be very limited in its ability to intervene in these rights. And so the Supreme Court addressed contraception in a case called Griswold versus Connecticut. There was a Connecticut law which banned the use of contraception, and this was challenged. The law was actually probably a little moribund at that point, but somebody felt it was important to get it off the books. So the Supreme Court found that having children was such a fundamental decision, and the decision not to have children was so fundamental that it was protected by the 14th Amendment, by substantive due process, which is the idea that there are just some rights that if the government wants to intervene, they should have a very, very strong reason to be able to. The Supreme Court also extended the substantive due process analysis to abortion and found that the decision whether or not to terminate a pregnancy was, again, something so fundamental that the government should not be able to intervene except in very, very narrow circumstances. And that was, of course, the decision Roe versus Wade, which for 70 years controlled the access to abortion in this country. The Supreme Court has recently overturned Roe versus Wade in the case of Dobbs versus Jackson Women's Health Organization. So abortion now is essentially controlled at the state level by state laws regarding abortion. And there is no federal law regarding abortion except for a ban on the use of federal funds for purposes of engaging in abortions. So I should say that even though Roe versus Wade has been overturned, Griswold versus Connecticut is still good law. However, Justice Clarence Thomas, in a concurrence in Dobbs, basically said that he thought that the substantive due process case analysis used in Griswold was incorrect and that it should be overturned, essentially saying that he did not believe that the Constitution does protect contraception. So this is something that is concerning to people, the idea that the overturning of Roe versus Wade might also lead to the overturning of Griswold. Now, I should say that one thing that many people do not realize is what a high level of public support there is for abortion. There is over 60% of people believe that there should be access to abortion, and with some limitations. This goes up significantly if you ask about abortion in the first trimester. This is supported by 70% of America. And I should also note that 77 countries allow almost unlimited access to abortion in the first 12 weeks of pregnancy. So this is not an outlier, but actually something that is very common internationally.
Thanks, Ken. And so just to kind of recap on the case law a little bit, Griswold protected the rights of families to use contraception. Roe versus Wade extended it to the right to decisions to terminate a pregnancy. So we know Roe was overturned, but Griswold still stands. However, through Justice Thomas's concurrence, as it sounds like, there's some sort of rumbling about whether that right to use contraception should stand or not. Although it does sound like there's some disagreement on that point from justices, and that it's just electorally or with lay people, there's public support for contraception and for abortion, certainly in the first trimester, not just in the U.S., but around the world. So thanks for walking us through that. So what's happening at the state level? You said, now that these Supreme Court cases have impacted what's happening federally, what's happening at the state level?
Well, since the Dobbs case has been decided, there's actually been a lot of movement at the state level. So right now we have 13 states that have imposed an almost total abortion ban. 7 states ban abortion, 7 additional states ban abortion after 18 weeks. 21 states ban abortion at some point after 18 weeks, and 9 states and the District of Columbia do not restrict abortion at all. So this is a much more limited regime than was put into place, that was in place before the Dobbs case. I should say that there is also an interesting new development, which is that because abortion pills are now available, it's not clear that all of these limitations on abortion have been effective. There are people who are getting abortion pills through the mail or through other ways who are essentially being able to engage in abortion in states that ban it medically or ban it from being done in a clinic or in a hospital. And so the efficacy of these state bans is really not clear, making this even a more complicated situation.
Yeah. And so it sounds like these state abortion laws and also the state of the science is just making a lot of uneven implementation. So, what could be done at the federal level? Could Congress pass laws protecting access to contraceptives and abortion? And I'll say, I think we're taking the view that bodily autonomy is a fundamental right. This should be protected by the Constitution. And so, what does this look like through legislation?
Well, what's interesting is that traditionally this has always been left to state laws and then, of course, was controlled by Roe versus Wade. So there really has been no federal law contraception. And the question is, of course, does the federal government have the authority to regulate abortion? And interestingly enough, the regulation of abortion could be done through the Interstate Commerce Clause. Now, doesn't sound like the most obvious place for abortion restrictions. However, the Interstate Commerce Clause is the basis by which the federal government and the Congress regulate commercial activities, and medical care and even sale of abortion pills would be considered to be commercial activity. So this is something that now is relatively common for the federal government to use the Interstate Commerce Clause to regulate things that seem a little far disconnected from the sale of the sale or regulation of the actual activity, but it's really a very strongly established case law. And the other interesting part of the Constitution is that because of the Supremacy Clause, federal law can supersede state laws. It's possible that the federal government could not only pass laws regulating abortion, but could essentially supersede or prevent the application of any state law that limits abortion. This federal legislation has been proposed both for contraception and for regulation of abortion. So, for instance, Senator Schumer, made the Right to Contraception Act a priority when the Democrats controlled the Senate. Schumer brought the bill to the Senate floor, where it was supported by essentially all the Democrats. However, Republicans opposed it. Only Susan Collins and Lisa Murkowski voted for it. And because of the filibuster, which of course we've discussed previously, the Congress did not pass the Right to Contraception Act, and consequently, this is something that is still out there as a priority. Now, obviously, a law to protect contraception is not as important because contraception is still protected by Griswold, but the idea is that this act would be a backup plan if the Supreme Court ever did overturn contraception. As far as abortion goes, it is certainly the case that the federal government could regulate abortion, and they could do it in any way they wanted to. They wouldn't have to replicate Roe versus Wade. They could, if necessary, or if they felt that this is where the people were, they could perhaps have a more limited protection, which would be consistent with what the majority of the American people want, which is allowing abortion in more of the early terms of the pregnancy. These kind of laws have actually been proposed ever since a previous Supreme Court case called Planned Parenthood of Southeastern Pennsylvania versus Casey. This was a case about 20 years ago that provided for parental notification and the 24-hour waiting periods. A state had established those, and the Supreme Court upheld them. This was seen as cutting into Roe versus Wade, and a proposal called the Freedom of Choice Act was introduced in order to restore the original limitations of Roe versus Wade, which was to have abortion be more unrestricted. So the Freedom of Choice Act has been around for a while. It's been introduced in various Congresses, and this is something that could be used to restore an abortion regime similar to Roe versus Wade, or in a way that would be more reflective of where the American people stand on abortion.
Great. Thanks, Ken. And something this unlocking for me and hearing you talk about it is I think that when we've been approaching the right to contraceptives and abortion up until maybe this year, we've been thinking that the Supreme Court cases, or up until last year, Supreme Court would be more protective than federal legislation for the country. And we've kind of been seeing that the role that the Supreme Court has been playing more recently, being not as protective as we thought for rights. And so I love this proposal of kind of double strapping us to have federal legislation and then think about how the Supreme Court could play a role in supporting fundamental rights in future eras, potentially. So the key takeaways I'm getting from this conversation is almost everyone supports legal access for folks to plan their families. That includes contraception, that includes abortion, especially in the first trimester. A majority of people are supporting that legal access to abortion in the first trimester. The federal legislation pathways regarding reproductive rights are possible, and that it could really end one of the most disruptive public issues in the U.S., as well as kind of even out all of this disparity that we're seeing across states and how this right is being protected. So thank you for walking us through that. Thanks to everyone for listening. We're looking forward to our last few proposals with you all. To get in touch with us or to give us your feedback, feel free to leave comments, subscribe, like. Hope you're enjoying the content. And if you want to, help us with these proposals, make them a reality, you can always email us at production@constitutionpod.com. Thanks all. Thanks, Ken.
Thank you, Sadhna.